Good afternoon and welcome to our first residential property forum of 2024. We're very grateful for you attending today and for your contributions, and also those of you that attended last year for some of the follow-up we had from you. We'll be talking today, Ian Quell will be talking about some issues which have risen, and we also have Michael Hanover here to talk about some boundary issues. And then we'll go from there, ask some more topics and questions from you. We've already had some queries through from you already, but most importantly, this is your forum. So if there are any points that occur to you, any things that come out of the conversation that you need to discuss, then please make your comments either through the chat function or by raising your hand, and we'll try and involve you. But please, let's get on with it. Ian, over to you.
Yeah, thank you very much, and good afternoon, everyone, and thanks for joining us. I'm delighted to be attending once again the Northern Irish Forum for Residential Conveyancers. As Robert was saying, these are your events, they're not my events. So I've got some topics that I'd like to discuss, and I'm delighted that Michael Hanover is with us today. So we're going to talk about some boundary issues today, which will be interesting. But as Robert was saying, there's a chat facility. Type in if you have any burning questions or burning issues that you'd like to discuss before we end today, and we'll happily incorporate those questions and endeavour to deal with them. And if you want questions or topics, or indeed would like speakers to come along for future events, again, if you let us know, then feel free to put something in the chat box. And again, just before we sort of delve into what we're going to be talking about today, remember you can email me or email Robert Kelly at any time with any questions or queries that you might have or would you like incorporating into the next forum, and we'll keep them and store them up and make sure that we discuss them on the next occasion. So bearing that in mind, thank you very much indeed for coming along today. Welcome. Normally, of course, Stephen Smith, Robert's colleague, sort of starts the ball rolling and sits in the background to deal with any IT issues, but Robert and his colleagues are sort of sitting ably to assist if there are any issues. As far as my email address is concerned, it's there, Ian at iqlegaltraining.com. We are going to try and organise a conference in Belfast at some point in the next year, probably in the autumn time. So if anyone has any topics that they'd like to be covered in a face-to-face event, let me know and we'll see if we can incorporate that into our plans for later in the year. But my first task today is to introduce to you Michael Hanover. Michael and I had a chat on Friday when he was in Glasgow, and I'm delighted that Michael has taken the time out today to join us to talk about some issues associated with boundaries. As a residential conveyancer that looks at problems associated with negligence claims and client complaints, the problem with boundary identification, getting things right with regard to boundaries, setting realistic client expectation relating to boundaries is so important. And it's brilliant to have someone like Michael with his experience relating to his surveying work and dealing with boundary problems and issues along today. I'm so grateful to him for sparing that time and to share with us some of his views and some of his opinions and his expertise and guidance. So, Michael, first of all, thank you for coming along. And the first thing I would like to know, Michael, is that, you know, as a conveyancer, I'm invariably looking at the description of the property or plans. And one of the things that worries me with regard to plans is who's produced them.
Yep. Can
I rely upon them? And what data or information is a plan actually producing for me as a conveyancer? So, Michael, my first question to you today is, can you just share with me how you would deal with a sort of plan that was put across your desk if there was a boundary issue or a boundary problem that you were being asked to assist with?
Yeah. Yeah, one of the problems is, as you rightly pointed out, is the provenance of the map that's actually attached to the conveyance. So actually, who produced it? What was the skill of the person who produced it? Was it as a result of a trace of an ordnance survey map or something like that, a historical map? Or was it actually produced as a result of a site visit and survey? Mm-hmm. It's unusual for maps to be actually produced as a result of a site survey. And people rely heavily on the Ordnance Survey mapping as the basis for property registration purposes. And therefore you have a series of problems from the very beginning, because if the map has been photocopied, it stretches. So it stretches along the long axis. So in the process of copying the map is distorted. If it's a trace, as it may have been, if the map is 50, 60 or 100 years old, then it's probably more diagrammatical in terms of its actual representation of the boundaries. So one of the things that we do as surveyors when we're trying to determine a boundary, we look at other evidence that actually helps inform us as to what the boundary actually is. So we will look at historical mapping, we will look at aerial photography if it's available. Google Earth has been an immense help in actually seeing how perhaps maybe boundaries have evolved over a period of maybe 20 years or so. We can get good aerial imagery from as I say, Google Earth from about 2000. Before that, it's actually it's pretty poor quality. And then we can also go back to the Ordnance Survey archive and get copies of historical Earth photography that the Ordnance Survey themselves have taken. So one of the things that we're trying to do is actually look at the map and see what the line on the map actually represents on the ground. And if there is a dimension on it and we conduct a survey and we can find that there's a good relationship between the stated dimensions on the map and what we've actually obtained by means of a more modern survey, then that gives us some indication that maybe the map is accurate. But you have to take, you don't look at something and just go, okay, it says it's 100 feet on the map, so therefore it's 100 feet on the ground. There's a lot of problems with that. If it's tape, you get what's called a catenary, where the tape sags in the middle, so it's not pulled straight. If you're measuring up a slope, you're actually getting the hypotenuse of the triangle as opposed to the base, and all mapping is use the base of the map of the triangle. So if you're measuring up a hill, you're going to get a longer dimension than you are actually if you're measuring on a flat plane. So there's a number of issues that you have to look at the whole thing in the round, and actually sometimes you're being a bit of a detective, actually looking for supporting documentation and as I say, other maps. Field traces, for example, now are very good, but we don't actually. Field traces sort of stopped in about 1980, maybe 1990, because it used to be that you had a published map and then you had a revision of that map. And what we have now is a process of continuing revision. So we can't say that this map was produced at this particular time.
Right, yeah.
When historically we can go to the archive and get a map from 1955 and we know that map was revised at a certain time. But because we're using digital maps now and the ACE maps, address centered extracts, we can't say that map is a snapshot of that particular ground at that particular time.
Yeah, I see that. So you see, Michael, one of the things I always say to conveyancers is, ideally, what I want is a description of the property that gives me a picture that I can rely upon. As you say, sometimes if a map has measurements or a plan has measurements on it, that's fantastic. But the point is, where are you measuring from and to? So sometimes you be able to say, well, yeah, I'm buying a site that's half an acre in size, but where actually on the ground does that half acre begin or end? And sometimes, particularly if you've had plots of land that are registered around you and you're not, the land registration system is not particularly precise. That means you basically get what's left. So what you think's half an acre from a registration perspective isn't.
Yes, but also people who prepare maps sometimes will include, for example, to the centre of the road. So you may find that there's a map and it says, oh, you've got half an acre, but the actual usable space on that area could be significantly less, because it takes in part of the adopted highway and to the centre of the road. So therefore, again, you actually have to be quite specific in terms of how that piece of ground is described. So it's unfortunately there is no hard and fast rules as to how maps are prepared. There, again, unfortunately, there's no regulation to say that the map has to be prepared by a competent person. and you often find that maps, people download an ordnance survey map from the website or whatever, and then just put a red line around it without actually thinking about what's actually on the ground. You've got to take into consideration things like the ordnance survey accuracy statements. You've also got to consider that, is the map of a location in the countryside where perhaps maybe it hasn't been revised for a long period of time. We had a personal, we were involved in a boundary dispute, and the area was in canopy, so therefore the ordnance survey couldn't have mapped it using photogrammetry.
Yes.
And we couldn't use GNSS equipment, which is centimeter accurate equipment, because the canopy was obstructing the satellite signal. So we used an optical instrument. And what we did was, in the distance, there was 3 properties which had been there for over 100 years. These were farmhouses. And we were able to measure using our optical instrument to these farmhouses. But whenever we overlaid them onto the ordnance survey map, the ordnance survey actually had them out of position by about 12 feet. Each of the properties. So again, you can't say that the ordnance survey map is always going to be right. It's not. It is a product of its time. And if that map was prepared before the Second World War and not revised, more recently, then it's unlikely that it's going to be accurate to what you consider to be accurate by today's standards. Yeah,
that's good. I mean, I saw that once in a building in London, and the surveyor was saying to me, well, I'm taking my measurements from the corner of that building, but I know that that building isn't where it should have been. It was out by about, I think it was 8 centimeters or something. So he was saying, so I've now got I'm out. My tolerances are certainly 8 centimeters before I start. So you're quite right. So the other thing that I think is so important is, the idea of being able to refer to physical features. That's fantastic, as long as the physical feature is permanent. So I've seen things like a riverbank that's been altered. I've seen a situation where there's been reference in an old conveyance to a tree, but that tree, it transpires, was felled in 1946, and another tree put in its place, but not in exactly the same place. And therefore, here we are in 2022, and yet there's an oak tree in the spot. So let's take our measurements from that. But hang on a minute, it's not the same tree.
One of the problems, like we have what's the general boundary rule in the UK and Ireland. So we have and it's the concept of general boundaries. Whereas in Europe, in America, Canada, Australia, they have a precise cadastre, which means that the parcel of land is very well described, and it's actually mapped by a licensed and qualified surveyor. In those countries, the surveyors acting as an agent of the court, so he's stamping the drawing to say it's correct. And if you're in America, you can go to the local courthouse and you can pull a plat which has been signed and stamped by a surveyor maybe 50, 60, 100 years ago. And the corners are marked. They put in rebars in the corners, and they actually have angles and distances to the next point. We don't have that here. So the ordnance survey map, which is used as the basis for the land registry mapping, the purpose of that map in the first place was for taxation. It wasn't there to determine, who owns a hedge, or do you own to the centre of the hedge or the far side of the hedge or a wall, whatever. So we're dealing with an imprecise system. And one of the problems that I see as a surveyor is no one argues over half an acre, or 3 meters or 4 meters of land. People argue over a foot. Because that's imprecise. And what's happened is, you have a boundary feature such as a hedge, and maybe somebody takes it out and builds a fence or puts up a wall. And the question is the fence or is the wall in the right place? And then people are looking at land registry maps and the red line. Oh, the red line says it's here, but the land registry map itself, disavows that and says it's for location purposes only, and it's only indicative of an entry on the register. So you're in a situation where you're looking for evidence of what was there, and and actually, does that feature on the ground actually reflect what's actually on the map itself?
Yes.
You know,
Yeah.
I'm very much of the mind that the feature on the ground is what is there. Maps can be wrong, you know,
Yes.
but
Yeah.
and particularly, you know, or say ordnance survey maps are within their stated accuracies, but a map that's prepared for in an architect's office or whatever, usually architects were the people who actually prepared these maps historically.
Yes. Yeah.
Because it's only from the 1990s really that there are licensed, or sorry, there are qualified land surveyors actually working in private practice and able to produce these maps to a high degree of accuracy. So, yeah, it's very much a case of, you know, you're trying to pull evidence in from different sources to try and actually make a determination and you know, supported by evidence of where you believe the boundary to be. But again, it's only an opinion, and opinions can be challenged.
Yeah, a couple of points I'd just like to take you up on, if that's possible, Michael. The first one is that I always say to practitioners that when you're instructing a land surveyor, it's important from the outset to ascertain just what his or her role is. Are you instructing a land surveyor to give you ammunition as an argument as to boundary location? Or are you instructing a land surveyor that potentially is going to be giving expert evidence before a tribunal or an arbitrator or a court? And one of the things I often see, if the latter is in fact the intention, the fact that the lawyer must ensure that the surveyor is given both sides of the story. So it's all well and good me giving you my documentation, my statements, my plans, but in essence, anything that you produce is going to be fundamentally flawed unless you've seen what the owner of the land adjoining has also got. Yes. So again, someone like yourself is going to guide the lawyer and say, look, I can't produce what you want without having to hand that evidence and that documentation. And do you sometimes see that with lawyers that they don't, that there's a confusion as to what they're instructing you to do, or how does that work?
No, I usually find from my instructing solicitors that they're aware of the role of the expert. Right, yeah. And they're not looking for an advocate, they're looking for an expert who's going to be independent and say where they believe the boundary to be. And, you know, they're there to act as to be of assistance to the court in terms of actually helping the court understand the issues at hand, and hopefully that the surveyor will be able to explain why he or she has come to the opinion as to where the boundary, where they believe the boundary to be. What I find is that we as surveyors, we'll conduct our own investigation. We receive a bundle from our instructing solicitor, but we also do our own investigations. We look at PRONI, we look at online archives, and we have our own means of obtaining documentation and in respect to the mapping and the boundaries. But then what happens is usually we produce our report, and then there's an exchange of reports. Yes. We produce our report. The expert for the other side will produce a report, and they will exchange. And then what we do is we prepare a response to the other expert. Yeah. Which we then give to our instructing solicitor. Yeah. So yeah. And then usually after that, then there's a meeting between experts to prepare a Scott schedule of items agreed and disagreed in advance of a hearing, you know. So yeah, there's usually a good understanding as to the role. I always make it clear to whoever's instructing me that I'm not there to be an advocate. I'm there to be an expert, and I'm not there to fight an argument for whoever's instructing me or whoever's paying me.
Yeah, that's a good point. And the other interesting point that you made, and I think it's so important for practitioners to understand this, that gathering evidence is so important, and that evidence could be statements from neighbours, statements from previous landowners, etc. It could be, someone once said to me, things like family photographs that were taken in the garden. Yep. It can be just as useful as professional photographs or aerial photographs or indeed anything else.
Absolutely. We were instructed, or I was instructed in respect of a potential claim for adverse possession of some land. Now the land was in town, and and I remember having a meeting with the barrister and solicitor at court, and I was just saying it's a pity we don't have any photographs of the site. The person who was claiming had said that they had possessed it in excess of 12 years. and they put up a fence around it. So it did have exclusion and what have you. But in the process of them putting up the fence, they'd taken some photographs.
Right.
And I just said, you know, it's a pity we don't have any. So the solicitor says, oh yes, the client, the other side did provide some photographs. So I was looking through it, and in the photographs, you could actually see the construction of a multi-story car park in the distance. Because it was in town. This was a multi-story that was being attached to a shopping centre. Yeah. And from that, we were able to ascertain when the photograph was taken. Because we were able to go through the building control and see whenever the various stages had occurred. So we were able to say, at the time that this photograph was taken, where you were actually putting up a fence, wasn't I'd say 12 years. It was actually 10 years and 6 months or 10 years and 8 months. Yeah. Which then destroyed his argument that he had. So yeah, it's funny where you actually, you know, where you can see things. And that's one of the things I would always say to my, whoever's instructing me, send me through whatever you have. Yes. I will don't filter it and say, oh, that's of no use, because sometimes what you may think is not of any importance, I may see something important in it. Yeah. Yeah. So send everything through. We filter it ourselves, and then if necessary, then we can take it further then. But that was an interesting one because the argument was that they had more than 12 years on it, and by their own hand, effectively, they'd shown that they hadn't. Really interesting. Michael, we were talking just before we began today about sort of general boundary rules, and you mentioned them again. And I think it's so dangerous from, if I'm a transactional property lawyer, I'm not going to be a boundary expert, but, things like the hedge and ditch rule, things like the fence and fence posts, etc. And the idea is that unless the deed that creates the boundary specifies the position, a lot of these sort of general presumptions, I think, are quite dangerous. And again, that then transmits to clients, and some clients have all sorts of ridiculous notions about how they identify boundaries. So I think there's three things really. What I always say to practitioners is, look, first of all, make sure that clients in a conveyancing transaction have reasonable expectations as to what you can do. Without your expertise, Michael, it's going to be difficult, if not impossible, for a conveyancer or a client to determine the location of a legal boundary. Yeah. And the moment you start relying on old principles and common law presumptions, that again becomes dangerous. I once dealt with a matter where someone was propounding the hedge and ditch rule, but then it transpired that the hedge was planted 30 years after the ditch had been done. So, the whole presumption of the hedge and ditch rule just was blown out completely out of the water, So what would you say about what are the common misconceptions that you encounter with regard to common law principles or things like that? The main misconception that I get is that, the land registry map is conclusive. People will say, oh, there's the red line, and the red line is where the boundary is. No one reads the bottom left-hand corner and where it says, it's only indicative of an entry in the register. There's that. I mean, the other thing is that ordnance survey map boundaries. And ordnance survey don't map boundaries; they map physical features. Whether the boundary and the physical feature align, if they do, it's more by accident than by design. And then you've also got, the land registry title plans show exactly where the boundary is. Again, it's the red line thing. Ordnance survey maps are accurate. The notion that ordnance survey maps you can scale from, I remember one time doing a topographic survey for an infill scheme, and the architect was saying that he had measured off the ordnance survey map to within, millimeters. Now, that's fine and well saying that, but it just in practice it just can't happen. The thinnest line on an ordnance survey map is 0.2 of a mil. Okay, so that's on a published ordnance survey map, 0.2 of a mil, which represents 10 inches, 25 centimeters at 1 to 1250, and half a meter at 1 to 2500 scale. So
your legal boundaries somewhere
Yeah.
in there.
somewhere there. Yeah. So you know, you have, so that's one of the real problems. One of the things that I would suggest to people who have, you know, because solicitors have to certify maps and boundaries now, you know, it's a good idea to get a ground truth survey carried out to see whether or not what is actually on the ground is accurately reflected on the ordnance survey map, and to see if there's any you know, inconsistency between how the ordnance survey have actually shown the physical boundaries on the site, you know, with what's actually there. So you know, but then I suppose, like everything else, there's a cost involvement to that. And you know, the property process, purchasing a property is not a cheap process. You know, the property itself is not cheap, so it's an added cost, and sometimes maybe some extra time has to be spent on actually doing the survey. You know, but you know, given the fact that a property transaction is probably one of the biggest spend in most people's lives. You know, you don't buy a car without getting checked. You know, so check your boundaries, because this is one of the things people say. Oh, you know, this is where my boundaries are, and particularly there's dimension on it. I mean, you know, I had a situation once where my client had bought an apartment, and there's a parking space out in front of it, and next door neighbor moves in. He was a retired teacher, got a copy of his deeds. The deeds were clearly wrong, but he was insisting that these dimensions were correct. As a result, he measured from the inside of his house out and discovered that the dimension that he says he was conveyed, which was actually the map attached to the conveyance, took him into the car parking space, into the middle of the car parking space, which he then proceeded to excavate. So he started ripping up the brick pavers that were the car parking space. So my client then couldn't park her car, our car parking space, because he had decided that was part of his garden. Despite clearly the dimensions on the map being incorrect. So yeah, it's sometimes a little knowledge is a dangerous thing, you know.
Absolutely, yeah. So I think that in summary, what Michael, there's one more question before we sort of finish, Michael. But just in summary, I think as a conveyancer, it's important to set realistic client expectation, to explain the basics, that it's going to be difficult, if not impossible, for me as a conveyancer to identify legal boundary, that there might be steps or measures that can be taken that will give us a more accurate fix as to boundary, but that's going to be at a cost. And that leads me to the question, Mike, and again, I'm not going to hold you to this, but could you give an indication of the sort of cost that a conveyancer or their client could incur where you're being asked to sort of provide an opinion as to boundary location? And is it possible to, I mean, again, I suppose it depends on how much time you spend, but a sort of, if you could give a window as to what sort of expense or cost the client could be put to, where the client says, well, no, actually, I would like to know in a little more detail just where my western boundary sits.
Yeah. Normally, we operate on two levels of service. One is an opinion where litigation hasn't occurred, and then there's a boundary report. It's a mandatory requirement for chartered surveyors who are acting as expert witness that they prepare a report that complies with civil procedure rules and actually meets the requirements of the RICS practice guidance for surveyors acting as expert witness. So you're talking about £800 for an opinion. If it has to be worked up to a report, you're probably talking, well, it depends on the complexity. Basic boundary, relatively straightforward, you're talking somewhere maybe £1,800, something like that. Then you can go up into the several thousands. I'm involved in one where it's very complex. We just actually finished the report. The report runs to 120 pages, and it's run into several thousands of pounds. The most expensive boundary dispute I was ever involved in was Lissadale House in County Sligo, which is the home of Countess Markovitz, who was the first woman MP elected to the House of Parliament. She was a Sinn Féin MP. And now Sligo County Council decided that there was a right of way across this land to a beach. My clients, who were both senior counsel in Dublin, had bought this as their country retreat and spent millions of pounds on doing it up. It ran for 5.5 months in the High Court in Dublin, and it cost £7.5 million, €7.5 million in costs, which Sligo County Council were obliged to pay because they lost the case. Actually, when it went to appeal, they lost the case. Now, my fees were minuscule, but but then you had the cost of running a High Court action, which there was experts brought in from all sides.
Okay, thanks for that, Michael. And Michael, so if people, you are available to provide your sort of report either as a preliminary issue or as part of a sort of potential court process. Michael, thank you so much for coming along today. It's really interesting. If anyone has any questions, fire away in the chat. But what I'm going to do, Michael, because I appreciate you're a very busy man, is thank you very much for attending today. Speak soon. And thanks again. Thank you very much. Lovely. Thanks, Michael. Cheers. So let's have a look at some other topics that I'd like to discuss today. The next thing I want to talk about, and again, please put in the chat if there's anything you'd like to talk about, is the Building Safety Act. And just to let you know what's happening in England and indeed in Scotland and indeed in Wales with regard to the Act, and just to sort of draw to your attention the fact that this will become law in Northern Ireland at some point. And now we've got the Parliament sort of functioning again, then the word seems to be that this will be on the statute book pretty soon, to be honest with you. The Building Safety Act is designed to promote and protect residential leaseholders in high-rise buildings. But what we've had in England, Scotland and Wales is a very, very extensive piece of legislation that applies not just to residential units, but potentially to commercial units in high-rise buildings, but also applicable in connection with all different types of building, including new homes. So to think that the Building Safety Act is just going to concern you and your practice if you're buying and selling leasehold property in high-rise flats and apartments in Belfast and other city centres, I think is wrong. There are parts of the Act that will apply to all aspects of residential conveyancing. Where the Building Safety Act becomes sort of focused on building safety for high-rise buildings is in situations where we're encountering relevant buildings and high-risk buildings. A relevant building is a building that's more than 5 meters in height and that has more than 5 stories in height or more than 11 meters in height. A higher risk building is a building that contains more than 7 stories or 18 meters. With regard to a relevant building, the Building Safety Act prevents landlords from recovering remediation costs for building safety defects. Building safety defects, risk of fire or risk of collapse of the building. So where you have work that's been done in the past relating to fire safety or relating to risk of collapse that now requires remediation, Schedule 8 of the Building Safety Act limits landlords from what they can recover from leaseholders, requiring in essence the landlord to recover from anyone that actually did the work that's still around and can be sued, or 2, recovering from government grant schemes that are excuse me, established excuse me again, established for that purpose. And then finally, once both of those avenues are exhausted, then and only then to recover from leaseholders. So if you've got a relevant building, more than 5 stories, more than 11 meters in height, the leaseholders are afforded some protection for some remediation costs. If a building is below 11 meters or 5 stories, then there isn't any protection. But that's not to say that there are other parts of the Building Safety Act that don't apply. The next section of the Building Safety Act that applies relates to higher risk buildings, more than 7 stories, more than 18 metres in height. They are relevant buildings, so what I've just said applies, and in addition to that, there are additional duties and responsibilities on the landlord and building owner. Those duties and responsibilities include the production of a whole raft of documentation that highlights assessment of building safety risks, what remediation or mitigation is being done in connection with those risks, requires communication with leaseholders or occupants of flats and apartments in the building, and creates a whole new tier of duties and responsibilities that the landlord is now going to incur because it's a higher risk building. And the significance of that is the landlord is going to incur far more service charge costs that are going to be transmitted to leaseholders. So what I say to practitioners is, where you are acting on behalf of a client who's buying a flat or an apartment in something that is a higher risk building, that client needs to understand and appreciate that there is a likelihood that they will be paying additional service charge costs as a consequence of their building being a higher risk building. And the other thing that you'll find in that building is that you'll get implied terms into residential leases. Those implied terms compel the landlord to provide the services that are designed to mitigate or eliminate building safety risks, and leaseholders are required to do nothing that could impact on what the landlord is attempting to achieve, and allows the landlord the right to inspect flats and apartments in the building. So just so that you're aware, what you're going to see at some point in the future in Northern Ireland is the Building Safety Act, in its glory, as it were, becoming law. What you've had in Wales and in Scotland are two different things. In Wales, the Building Safety Act has been introduced, but with regulations that are slightly different. So, for example, a relevant building or a higher risk building in England has to have at least 2 residential units. In Wales, there's a requirement that it only has to have 1 residential unit. But the view is that Wales, when all the regulations are brought into effect, in Wales you'll have the equivalent of the Building Safety Act in its entirety becoming law. In Scotland, what you've got is parts of the Building Safety Act being incorporated into Scottish law. Notably, the creation of an entity in England called the Building Safety Regulator to oversee building safety, and a new entity being responsible for building regulations in high-rise buildings. Again, in England and Wales, the Building Safety Regulator has that function. In Scotland, a separate entity is responsible for building control for high-rise buildings. So rather than local authorities having that responsibility, you've now got a separate body, as I say, in England called the Building Safety Regulator, with regard to that duty. So the Building Safety Act is something to watch out for. It has caught English lawyers by surprise. It became law in June 2022. Here we are in February 2024, and I am still convinced that the vast majority of residential conveyancers do not understand how wide-ranging the Act is. The second thing that is interesting, scary in some respects, is how few landlords or those advising landlords have grasped the significance and scope of the extent of the Building Safety Act. So I am, and we're coming up to 2 years since this piece of legislation became law, I am still being asked pretty naive questions by those that are landlords or building owners or those advising them about building safety management as a consequence of the Act. So all I'm doing in this section of the presentation is just drawing to your attention the fact that this will impact on your work in connection with the purchase of flats and apartments in leasehold, but also has the potential to apply to any new property no matter what the height of the building, no matter how many residential units within the building. And you may also see some radical changes to building regs and building control. The next thing I want to talk about is how we report on title in conveyancing transactions. And again, the importance of making sure that when we're reporting on title, we are reporting to the clients everything that we have identified as part of the due diligence process, search results, inquiry results, etc. Also, that we report to the client what we are told about in connection with the title that the seller is offering. But we also, I think, need to explain to the client the terms of any mortgage offer, the content of any survey, and the thing that I want to focus in on today, we also need to address how we deal with inspection of the target property. So my first question to delegates today is how many people attending today would inspect a property that a residential client was buying? So can we put that in the chat box, anyone? Josh, Claire, Jill, how many people would, Jonathan, how many people would inspect the property? You're acting for me, I'm buying a house on the outskirts of Belfast. Would you, as a matter of course, inspect that property on my behalf? Can I tell you, the vast majority of practitioners wouldn't. And the vast majority of insurers would say that you shouldn't inspect in the context of a residential transaction. I would add that if you ever did inspect a property on behalf of a residential client, you should be explaining to the client why you're inspecting. So I'm inspecting the property because, as we discussed with Michael, there's an issue with regard to the western boundary. Where we're not inspecting, of course, we've got to tell our client to inspect. I assume that you all do that. Would you tell me as a client what you're wanting me to spot or to do when I inspect? So do you explain to me that I will be bound by anything that I see when I inspect, and that I'll be bound by anything that a reasonable inspection would have revealed? Do you do that? Does your retainer, does your report on title cover that off? Certainly, I've been doing a lot of work in the last 2 years, really, on reporting on title. And one of the things I frequently see being overlooked by conveyancers is this one, recommendation that the client inspects. Two, that the client is told what to do when they inspect and what to look out for. And three, that they report to you what they see during that inspection. And I think it's something that needs tightening up, because if we're not inspecting the property, we're relying on the seller disclosing to us issues that are potentially important, and we're relying on our buyer client disclosing to us anything that they see when they inspect. Well, that presupposes that the client knows what they're looking for, and also presupposes that the client will report to us what they see. I think we've got to drum that into the client, to be honest with you. On the issue of reporting on title, do you, as a firm, have a standard form of residential report on title? Again, one of the things that insurers are really interested in is making sure that as a firm we have standard processes and procedures. And one of the things insurers are really interested in is, do you have a standard form of retainer and a standard form of report on title in residential transactions? Don't know if any of the local law societies or the Northern Irish Law Society have produced a standard form of report on title. The Law Society of England and Wales has got a standard form of report on title, and a lot of search providers are now producing reports on title that can have data migrated to them. So they're sort of described as being electronic reports on title. Don't know if anyone's seen those, but can I ask, does anyone have their own form of report on title? Is there a sort of precedent that people use? it's important that you're dealing with client inspection in that report. The most common thing that you're going to say is, I advised you that you should inspect the property. You tell me that you have inspected the property. You haven't reported to me that there was anything of consequence as a consequence of that inspection. And as I say, it presupposes that you're telling the client what to look out for. And what you're telling the client to look out for is, flowing on from what Michael was saying a little earlier, any sort of inconsistencies with regard to how the property is described or how plans show the property and boundaries. It's important that the inspection identifies who's in occupation of the property. Are there any third parties in occupation of the property who aren't joining the contract or party to the contract? To identify excuse me, state and condition of the property, and to check that any information that's been provided by the seller is consistent with what the client sees. All of that is so important. The next thing I want to talk about, and again, no one's put anything in the chat box about anything they'd like to discuss, so I'll just continue on with my list. Avoiding negligence claims. Since we last got together, I've had a few meetings with some professional indemnity insurance brokers, and they talk about effective communication being so important as part of the conveyancing process. So let's break this down into 3 areas, and let's just see what we mean. 1, when we're onboarding the client, when we're scoping the retainer, making sure the client is aware of what we're doing, the limitations of what we're doing, and what we're not doing. What would a client potentially expect us to do that we won't be doing? The obvious one is inspecting the property, for example, or advising the client on valuation or surveying issues, perhaps, is another. So the retainer is important. Then what we should be doing is, when we are about to exchange contracts, we should be reporting on title, as we've just discussed, highlighting to the client what our due diligence reveals, what the seller has revealed to us, what has been revealed by our buyer client if they've inspected the property, advising our client on co-ownership, advising our client on the terms of a mortgage offer, survey, etc. As far as issues that occur between the two, there are some important points to share. Point number 1, where you identify an issue, or where the client flags up an issue, or the seller's conveyancer or solicitor flags up an issue, how do you deal with it? One of the things that insurers are really jumpy about is where there are outstanding issues during the conveyancing process, how they are dealt with. It might be that an issue has been raised but hasn't been resolved satisfactorily. It is important that in the report on title, we explain that position. On the other hand, there may be an issue that's been identified that's been resolved, in which case the report on title should deal with it. So what do I mean by that? Well, going back to Michael's sort of comments earlier, it might be that during our due diligence, we've identified an issue with adverse possession, or an issue with regard to inaccurate boundary, or something of that nature. It may well be that that's been resolved by a statutory declaration from the seller, or a revision of a title plan, or a report produced by Michael or another land surveyor. On the other hand, we might have an issue that's outstanding, a missing deed or a missing document that requires a title indemnity policy from Stewart Title, for example, in which case it's important that the client in the report on title has explained to them that the issue that we identified in connection with a missing title deed has not been resolved, but we have taken out a defective title insurance policy to provide you with protection as a consequence. So during the life of the transaction, it's important that we identify issues When we're producing a report on title, we highlight those issues and explain that the issue is resolved or the issue is unresolved, and then highlight to the client the risk of that impossibility of resolution. And I think that's one of the things that's so important to deal with. As a conveyancer, your job is to highlight risk, the risk associated with an inability to identify boundaries, the risk associated with an incomplete title, the risk associated with a defective building, a problem with a roof, etc., or with contaminated land, or whatever the issue is that due diligence has revealed. So this point about communication, I repeat, scoping the retainer, making sure client is aware of what we're doing. So important to provide you with a defence to any allegations in negligence or breach of contract as a consequence of your conveyancing work. During the life of the transaction, highlighting or identifying issues that have been spotted, and where those issues have been resolved or dealt with satisfactorily, then fine. Where issues have not been identified satisfactorily, have not been resolved satisfactorily, flagging that up in the report on title. It is then important to highlight to the client the risk associated with that issue outstanding. So if we look at boundaries, the fact that we've been unable to clarify the position with regards to the western boundary to the property could mean that you are vulnerable to an adverse possession claim, could mean that litigation ensues with regard to that boundary dispute, etc. So it's important that clients are told about the consequence of that issue being outstanding or unresolved. I was talking to an insurer last week about this, and what they said is it's important that clients understand the consequence of an issue that remains outstanding, or a consequence of the advice that you're giving to the client by you as a practitioner. Very important indeed. Avoiding negligence claims involves doing the simple things well, communicating with the client. And before we leave this topic, there's some points I want to make. If you're sending me a report on title, I want you to ask me to confirm that I've received it, to confirm that I've read it, and to confirm that I've understood what the report is saying. I would also suggest that you invite me to generate questions if I have any. The reason I suggest that that course of action is adopted is to provide you with ammunition to defend any claim that I subsequently bring against you. By that I mean, it's important that you have ammunition to be able to confirm that you explained to me what due diligence you'd undertaken and what the conclusions were with regard to that due diligence, that you explained to me that there were outstanding issues and the consequence of those issues being outstanding. Those are the things that I think are so important. On the issue of boundaries, just sort of confirming what Michael said, a few points. Point number one, make sure clients are aware of the dangers associated with any plan that is produced by you or generated as a consequence of the due diligence process. To highlight to the client how property is being described in the contract or in the title. To explain to the client that the conveyancing process is pretty imprecise with regard to boundary identification. To explain to clients that where there is real boundary sensitivity, the only way of clarifying that sensitivity is to get a report from someone like Michael in order to get a more accurate fix as to boundary location or to enter into a boundary agreement with a neighbour. If you are creating new boundaries, a few points really. First point, as Michael was suggesting, peg the site out or stake it out and take photographs. If you're referring to measurement, have sort of some form of fixed corner point that you're able to take measurements from. I think it's Germany where they put a sort of concrete post in the corner of a site and take measurements from that, which means, as I alluded to when I was talking to Michael, you have a fixed starting point from which to measure and from which to take measurements. If you are providing stakes or pegs to indicate the location of a boundary, as a boundary line, a legal boundary is a pencil line between my title and your title, indicate where on the peg or the stake the actual boundary is. So the center point of the wooden peg or the western face of the wooden peg is the boundary. These sorts of things are important, but setting realistic client expectation, in my view, is the most important point of all. What I want to do now, and again, there's no one sort of raised any issues in the chat, either to discuss this time or next, so feel free to do that before we finish. But what I'd like to do now is just to remind you that these events are sponsored by Stewart Title, and I remain grateful for Stewart Title to inviting me along to these events, and to understand that it's possible to get title indemnity insurance relating to defects in title with regard to problems, excuse me, with servitude, where there are restrictive conditions on title, to take out an indemnity policy to protect where it is impossible to identify if the restrictive condition is enforceable or not, and if so, by whom, and also to deal with planning and building control. Does anyone have any questions or issues with regard to Stewart Title? If you would like to know more about bespoke policies or their solutions online policies, then do feel free to contact Robert Kelly and his contacts John and Liz from Stewart Title, who look after the Northern Ireland area. But as there is nothing in the chat, what I intend to do at this point in time is to thank you all very much indeed for attending today. As you can tell, I've got a terrible sore throat at the moment, so I apologise for my coughing and spluttering. At least as this is a virtual meeting, there's no risk if you're contracting whatever I've got, so I can sleep soundly in my bed knowing that. All that's left for me to do is to thank Stewart Title again, to thank Michael Hannaway for his involvement today, to thank you all for attending, and again to invite you to raise any topics or questions that you'd like us to explore at our next forum meeting. So I'll put my email address in the chat box. And what I'd like to do at that point is to finish and say thank you all for coming along. Stay safe. Look forward to seeing you next time. There is a forum every month. I will find speakers to come along and talk to you. I'll happily deal with any topics that you'd like examining. So thank you very much. Have a lovely afternoon. Thank you. Bye-bye.